Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law won.
Nick Maruchak joins us in the JCO Caravan. G'day, Nick. How are you?
Hello, Bowie. I'm great.
That's good to see you. Have you got a caravan?
No, but...
You got a boat?
No, I don't.
Got a trailer?
My car's not strong enough to tow anything, so I need to get the car first.
That doesn't... You're just a battler lawyer, aren't you? Battling lawyer. I'm sorry to hear that, mate.
I got a tent.
You got a tent?
Yeah.
We can upgrade that. It is completely amazing down here. Kit, as far as the eye can see, stretching right across the oval, and the caravan camping show. The showgrounds are absolutely packed. If you'd like to speak to Nick Maruchak, you can. 133 882. Any of your legal matters. Let's go to the phones right now. Nick, Catherine has called in. Hi, Catherine.
Hello, Simon. How are you?
Very well, thank you.
Good. Okay. Can I speak to Nick?
Far away, yeah.
Okay.
Yeah.
Nick, hopefully you can help me. On the 27th of June of 24, I inadvertently, and I say inadvertently because I wasn't expecting it, I signed an enduring power of attorney for a lady who was going towards Alzheimer's. And anyway, she's now got full-blown Alzheimer's or dementia, I'm not sure which. But I signed this, and now afterwards I worried about it because I don't want to be involved in an enduring power of attorney legally. I don't want to be involved in anything, and I'm not sure if I can revoke it. I've been to Citizens Advice Bureau, and I was told to get in touch with her bank and just put revoke on it. But then I was told I rang Landgate, and they said that, no, it's been lodged and I can't revoke it anymore. Now, the person I spoke to presumably is just a person who answers the phone. I don't think he's a lawyer. So I'm just not sure if I can revoke it.
Can you revoke an enduring power of attorney, Nick?
So... Catherine, you didn't create the enduring power of attorney, right? This other lady that's got dementia now created it, and that lady appointed you as the attorney to act for her. Is that right?
Yes, it's her brother, and I'm a joint attorneys with him because she was beginning to go downhill at that time.
Yeah.
Okay.
So he proffered these papers at me, and I signed on the spur of the moment because I didn't have time to think about it. And afterwards, I thought, "What have I done?" I'm so
all right. Let's. Yep.
Okay, so this is how it works. It's when you sign the papers, what you've done is you've signed an acceptance, and the acceptance basically says that you will agree to act as the attorney if this lady loses mental capacity. So that it's an agreement to basically stay on as attorney when the capacity is lost. There is one way that you can get out of it. Once the person's lost mental capacity, it's actually quite hard to get out of it. What you can do is you can make an application to the State Administrative Tribunal to get an order revoking or varying the terms of the attorney, and you will vary the terms to basically get yourself excluded. So that's the formal process involved. So it's actually you never sign a power of attorney so lightly because it is a responsibility you have to take, and you can't just step down with a simple resignation. But there are some other things you want to consider. One is you are jointly appointed with the brother. So there's two types of appointments. There's joint appointment, which means you both have to act together and you sign everything together, or it's joint and several, which means that he can act on his own, you can act on your own. So that might be a way, if going to the State Administrative Tribunal is too hard, then maybe the brother might be able to do the majority of the work as long as it's joint and several appointment, which means you can act independently. If it's not, then you have to have a look to see if there's any substitution attorneys. Sometimes you appoint the primary attorney. If they can't do it, there's a backup. So see if there's a backup and see the wording of it. But as an attorney, you still basically have requirements you have duties to the person. You have duties to act in their best interest. So if you're still in the form, you just have to hope that the brother does a good job and doesn't stuff up, because you're technically still responsible. So the formal answer is going to SAT, giving SAT a call, telling them that if you can't find a way to work with the brother.
Is that okay? Catherine, does that help?
I mean, he assured me that he wouldn't, but I'm just worried that because he's the only link between me being an attorney on my own, because if something happened to him, would I be it, basically?
Yes, you would be it, and then you would have to go to SAT. So in the meantime, because you have these duties, just do check in with the brother from time to time, make sure he's doing the right thing, make sure that money is not being misappropriated, because if it is, then someone can turn around and maybe blame you because you didn't take a proper interest in the estate and you agreed. So while you're still, until SAT makes an order removing you, you're still bound. So if something happens to the brother, you definitely have to go to SAT. And then another family member will step in. I don't think it will be a hard process. As long as she has other family members, in worst cases, then the government takes over.
Yeah, thanks, Catherine. Good luck with it. Let us know how you go. Hi, Peter.
Hello, Simon and Nick.
Hey, mate.
Hi, Nick. This is an odd one. Over 5 years ago, my wife had jewellery stolen that belonged to her and her late mother. There was a case in the Magistrate's court, and the person pleaded guilty and was charged. He went on probation and had a good behaviour bond, but the magistrate also made a court order that he make $9,000 reparatory payment. We've not seen hide nor hair of any of that. Just wondering, what is it that someone can be, found guilty of a crime and then nothing happens?
So it sounds like this was potentially a compensation order that was given, so that the criminal was ordered to pay you or your wife $9,000, right? Do you know if it was called a compensation order? So this is, the high level is this, Peter, that if a victim of a crime has the benefit of something like a compensation order, then the victim of the crime generally has the responsibility to apply to the court. If the thief doesn't pay within 28 days, you apply to the court. In this case, the appropriate court will be the Magistrate's court to actually enforce the criminal order. So you go through the enforcement process in the Magistrate's court. But you have to be wary of time limits, because usually these things do have an expiry date, and the expiry date that potentially might apply here is 6 years. So you said it was 5 years ago, so you might be within, sounds like you're good, as long as it doesn't go over 6 years. So what normally happens is you give the magistrate a court a call, say you've got this criminal compensation order and you want to enforce it. Then you file documents with the court, then you have to serve the documents on the thief, so you have to find where they are and stuff like that. And then the court will basically go through the process of finding out what assets the thief has. Can they sell the assets? Can they garnish his wages, his or her wages, if they're earning an income? So there's all this stuff that you have to go through to see what's in the kit of his assets that can be enforced. So you have to kind of do that yourself.
Where are you up to in that process, Pete?
Well, I'd started that because I'd spoken to the courts and I'd told my wife what she needed to do, but she's not interested in doing that. And, I mean, we need to find out where this person lives now, which we don't know. So it seems like we're pushing a barrel uphill with a flat tyre.
Yeah, because your wife will have to do it because she's the one that benefits from this court order. So she'll have to take steps unless she does something complicated, like assigns a debt to you. So if she assigns a debt to, maybe there's more complications there. And then you have to find where they are, and if you can't find where they live, you have to find, you have to try and, you can look at the electoral roll. So you go into the electoral roll and find out where they are. There's also services that help locate people, like private investigator type service, like AAC process service. We use them. They do something to find people. So you can, and then the end of the day is like, this person's a criminal. Do they have the money to pay you? They have $9,000. If they don't have $9,000, it is a barrel uphill because you can't recover anything, and if they don't have anything,
But I don't know if that helps. It looks like you've got some work to do on this one.
Yeah, well, looks like the law didn't win on this account.
Yeah. You fought the law and the law didn't win. Yeah. Thanks, Peter. Thanks for your thoughts today. That's a bummer. We'll take a break. We'll come back. It is, 17 minutes to 11 o'clock. I'm Simon Beaumont. This is Perth Today. This is Law Talk with Nick Maruchak from MKI Legal. Stay listening. And we're talking the law with Nick Maruchak from MKI Legal, and we're taking your calls. 133 882 is the phone number. Nick has phoned Nick. G'day, Nick. How are you?
Yeah, good, thanks. How are you guys, Simon?
Yeah, good, thanks, mate.
Yeah, I'll be quick with my question, Nick. Basically, I got some goods imported through a shipping company. I've never done it before, so I went to a shipping company. They'll know the ins and outs of what's required. And I signed a letter of authority where they would be authorised to act as my customs brokers. So my shipment arrived on the wharfs, and the Australian Border Force required some documentation to say that the goods that I had should clear customs, but they didn't have that documentation there. So I then acquired a number of charges in terms of wharf storage fees, quarantine storage fees, and all these other fees that came along because we didn't have the customs clearance documents that we required, which I signed for, like in the letter of authority. The shipping company would act as my customs broker to have all these necessary documents so that this wouldn't happen, so there wouldn't be, the goods would get off the wharf quickly and wouldn't have to go into storage and the other complications that have come along with the delay. We've got charged extra rental fees for having the containers over, I think 14 days is free, and then after that you get charged. So anyway, the bills. So anyway, they've held onto these goods until I pay all these extra storage fees. I have paid for them to deliver it, but they haven't delivered it until I pay these extra storage fees. And I'm saying, my question is, I've signed the letter of authority for them to act as my customs brokers to make sure they clear customs, and it looks like they've failed in that area. They're not willing to admit liability.
So, Nick, are these shipping agents located in Australia and WA?
Yeah, they are. Yeah, they're worldwide.
Yep.
They've been in business for 125 years.
Okay. And the goods that you ordered and the price, the goods that you imported, obviously, is it for a business or for personal use?
Personal use, yeah.
Yeah, okay. So you're covered by Australian consumer law, and basically with Australian consumer law, when you engage someone for a service, they have to provide that service with due care and skill. And so it has to be performed competently. And it sounds like these shipping agents didn't perform the service competently. Sounds like they were a little bit negligent, so to speak. So if that's the case, then you're entitled to either compensation that flows through the losses you've suffered, and these additional losses are potentially these storage fees that you've covered. So how much are the storage fees and the extra loss you've suffered worth?
$40,000.
Okay, $40,000. Yep. Okay. So
significant.
So then that potentially will be you potentially can make a claim against them, and I would probably engage a lawyer. You make a claim in the magistrate's court to recover that. Just bear in mind, it's probably good to get legal advice first on this, because if you go to the magistrate's court and your claim's more than 10 grand and you lose, you might have to pay their legal costs. So it might be one of these cases where you might want to do some sort of deal. Like if you get the majority of it, that's fine. But it sounds like it's either been a breach of contract that didn't deliver their service with due care, or a breach of Australian consumer law, which will apply potentially in this case. And so, yeah, you're entitled to recover your losses, and you have to start off by maybe sending them a letter of demand for it, see if you can work anything out. If that fails, then the lawyer's the next step. So
yeah. I did approach Consumer Affairs about it, and they reckoned that they didn't contravene any consumer laws. So the
question is whether they were negligent or careless in delivering their services. So with a shipping agent, a normal shipping agent in their position, would they have delivered it? Would they have made the same mistake? If it's something that wasn't their fault, or then probably not. But from what you're telling me, it sounds like we're careless. So I would probably just engage a lawyer for a 1 hour meeting, and then at least start the letter of demand process, see how much you can recover, because this sounds like there's something there, and it's you've got 6 years to recover as well. So
Yeah, is that okay, Nick? Can I leave you with that to have a think with that one?
Yeah, okay, then we'll have to have a think about that one. All right, no worries. Yeah.
Yeah, thanks, mate. 40 grand's a lot, no doubt.
Yeah.
The old fence issue. G'day, Matt.
How you going? There's been a few of these over the years.
Yeah.
So basically we've been in our place about 7 years, newly built house, big block, 1,400 square metres, and dividing fences up, and we had people move in, build on one side of us, and they were fine with paying their half of that fence, but then we've had another house built on the other side, and last couple of years they've just refused to pay, just won't pay. So I just wonder how do you enforce payments?
Yeah, so with the fence that needed to be replaced, you can only really recover payment under the Fences Act if the fence was defective in some way, right? So if you just replace the fence because you don't like the colour, then you can't recover it, right? So I'm assuming that the fence was broken in some way that you bore the cost of replacing?
No, we put the fence in, and they built a house next door.
Okay, so there was no fence there at all. Okay. Is that right? Sorry?
So there wasn't a fence there, mate, and you put it in?
No fence there. So we built our house and we put a dividing fence down both sides of our block.
Yep.
And at the time, that block was vacant. And they've now built a house there.
Yep.
So my understanding is under the Dividing Fence Act, they're liable for half the cost of putting that fence up.
Actually, I don't know. I've got new neighbours, and my fence, I didn't chase them for dough. I
believe so. I believe so, but I'm happy to have a quick look, and so I believe that yes, if the block is vacant, they still are required to contribute. That's my understanding. So,
how long ago did you put the fence in, Matt?
Oh well, it was about 6 or 7 years ago.
So 6 years is a deadline, though. So that's the problem. So you've got you got it. There's these limitation periods that basically make expire claims. So if it's more than 6 years, I think you probably won't be able to.
But we might try and find out. So, Matt, I'll put you back to Sean and Anne and leave your number there, and I might ask Nick of Nick's good nature to see if we can find out a little bit more on that one, because that's a universal one, I would have thought. David, I don't reckon we'll get to you, mate. Do apologise, but Robin, we can have a chat to you right now. Fire away.
Right, go. Thanks for coming back. We are, Bo. Yeah, we really enjoy you. Now,
thanks, Robin.
Getting
Cheers,
back
mate.
to the power of attorney, the lady rang in a little while ago. You would have had two witnesses on that form, would you? I'm just having a look at it now for my mother-in-law.
Yeah.
Yeah, so she wouldn't have just signed it in a hurry. Don't you have to sign in front of two people? I'm just checking that.
Yeah, that's right. So if you're creating the power of attorney, you have to have it signed in front of two people. One of them has to be an authorised witness. But when you're signing the form at the back and you're accepting as the attorney, so there's two parts to sign. The person who creates it definitely has to have a witness, but the person who accepts it doesn't have to have a witness. So that's just that's probably where the lady in the earlier call fell in.
Yep.
Then you've got joint and severally. How strong is the joint that you have to have a decision on every single bank transaction, or is it every single has to be by both people rather than the joint and severally, as in an independent one person only to sign on the account type thing?
Yeah. So if you're appointing two people and you make it jointly, it does make it a bit more difficult, because they always have to sign both checks. The bank would have to put special limits on the transaction to make sure both authorised it. So it does make it a little harder. So joint and several does make it a little easier for two people to work together to administer the estate. So if you trust them both, maybe joint and several is probably the way to go. But so a lot of people do pick that option.
Thanks, Robin. Thanks for calling in, mate, and thanks for the good thoughts. I hope you and your gang are enjoying the show in its current format and current iteration. We'll leave it there, mate. It's 4 minutes to 11 o'clock. Thank you very much. We're going to have a little look around and spend some of your hard-earned on a nice big You need a car first, don't you?
Yeah, but I'll have a look for future purchases.
Jessie's saying you need to go and have a look around. She's very, very persuasive, Jessie.
I will.
If you want to come down and see us, we're just outside the train station here at the Perth Caravan and Camping Show. Thank you, Nick. See you next week, mate.
Thank you, Bowie.
Cheers. Good on you. Nick Maruchak from MKI Legal. We will take pause. It is 3.5 minutes to 11 o'clock.